Good morning, everyone. I'm just going to wait for you guys to start tuning in. Hello, Instagram, Facebook, YouTube. How's everyone doing today? Gonna wait for a few of you to tune in. As you're coming in, say hi. Let me know where you're tuning in from. If this is your first time, definitely comment so I can give you a shout out. Good morning, Ashley on Instagram. Okay, let me put the comment thing. Okay, so let me introduce myself. My name is Ayesha Chidole. I am an immigration attorney. I represent clients all over the United States and in all 50 states. So your location doesn't matter. We're located in Atlanta, Georgia area, and Orlando area. But again, we take clients everywhere. Good morning, Justina from Los Angeles in YouTube, and Shari K. Good morning. If you want to schedule a call with us, call 407-995-6567. You can also send a WhatsApp to 404-333-8751. Tamika, good morning. This is your first time. Thank you so much for tuning in. Blue Trillion says, good morning from Georgia. Okay, I got to ask a question to those of you guys who live in Georgia. Nobody told me about the humidity in this state. It is so hot. And I'm from Florida, but it is so hot. Like the minute I walk outside, like I'm sweating because it's so humid. So that is something else I'm adjusting to in addition to all the pollens. Hey, Tamika from Queens, New York. Um, what part of Queens? I used to live in Queens. I used to live in Forest Hills. Okay, high above the law. Um, all right, so today I want to talk about who can petition for to get your green card. Like what family members can petition for you? Who makes you eligible for a green card? So there are two categories of green card applicants when it comes to family-based immigration. So there are those who are considered immediate relatives, and then there are those that are considered what we call family preference. So they're in the family preference. What you need to know is that if you are considered an immediate relative, it means that visas are immediately available to you, green cards are immediately available to you. If you're in the family preference category, you kind of have to wait for it to be available to you, meaning it might not be available to you. And this changes every month. So every month they release a visa bulletin and they'll say, okay, this month it's available to X, Y, and Z. So you kind of have to wait. So let's first start with family preference and those who have visas immediately available to them. So, of course, if you're married to a US citizen, this forgives a lot of stuff, right? Visas and green cards are immediately available to you. And the reason why I say visas is for those of you who are consular processing, meaning you're doing it outside the United States. If you're in the United States, it's an adjustment of status, so you just get the green card right away. So if you're married to a US citizen, you can your US citizen spouse can petition for you. Of course, there's some exceptions, and just two quick exceptions I'll talk about so I don't go off the rabbit hole. Is if you entered into the country without an inspection. If you entered into the country without inspection, meaning you didn't come here by like plane where somebody checks your passport and visa, or a checkpoint where someone checks your passport and visa, it means like you crossed the border. If that applies to you, then you cannot adjust your status unless you qualify for another relief, i.e., like if you qualified for VAWA. But if you came in without inspection, your spouse, who's a US citizen, can only file an I-130 for you. And then if you get approved for the I-130, then you need to do a hardship waiver. And if you get approved on the hardship waiver, you have to go back to your home country and then consular process, and that's how you come into the country. Okay. Second category of people are parents, right? So parents that are U.S. citizens can file for their children who are under the age of 21. Those people can get a green card through their parents. Okay. The third category of people are children who are over the age of 21. Children who are over the age of 21 can file for their parents. Okay. Again, these are people that would consider immediate relatives, meaning if they were here and i.e. they overstayed their time while they were here, they will still be able to adjust their status as long as they entered into the country with inspection. Again, there are always exceptions. Another good exception is if you came here on a crewman visa. If you came here on a crewman visa, and like that's for those of you who like are on a boat or like on a cruise or something like that, you can adjust your status based on your spouse, or your child or your parent, unless again you're self-petitioner based on VAWA or there's something else that qualifies you to. So there's certain visas that bar you, or if you have a 2-year requirement in your home country, if you have a J visa. So of course there are little nuances, but I just want to focus on the core people who can petition for you. Mimsy is asking a question, but I'm not sure what the context of your question is. But if the question is, so the question, let me give you, because people confuse this a lot. Again, the only child that can petition for their parents, the child has to be over the age of 21 and a U.S. citizen, okay? And similarly, the parent who's a U.S. citizen can file for their child who is under 21 as an immediate relative. Immediate relatives are those who have visas immediately available to them. You don't have to do a waiting time. You don't have to be, in status as long as you came in with a visa. If you worked without authorization, but never claims to be a U.S. citizen, usually they will forgive you for that. Then you have another category of people who are, considered family preference. Family preference is much stricter. So the requirement is a bit stricter, and it requires meeting certain timelines. And with that, you cannot be out of status. In order for you to adjust your status in any of those categories, you cannot be out of status. Or you cannot have violated your visa. I.e., if you are a green card, if your spouse is a green card holder, your spouse can file for you, even though it's considered family preference, but your visa and entry into the United States and your I-94 must still be active. You can't be out of status. You can't have worked under the table, because these are things that will disqualify you. So let's go through sort of the people there. So in that case, a parent can still file for their child that's over the age of 21. And they can file for their child over the age of 21 that's married. The two will require two different timelines. They're all still long. I mean, you're looking at probably like 7 years versus like 12 years if you're married, but it still takes a long time. Again, and then with with green card holders, a green card holder parent can file for their child, but their child under 21, and their spouse are actually current right now. So even though they're not immediate relatives, right now visas are currently available as of the month of June. And this has been the case for the last 2 years for spouses of green card holders and spouses of, and children under 21 of green card holders. But to adjust the status, the spouse of the child must be in status based on the definition I gave earlier. Now, if you're a green card holder and you have a child over 21, you can file for them. There is a wait time. However, if that spouse gets married, then they no longer qualify. So the spouse can't marry. So, depending on the age your child is, if your child wants to get married or whatever it is, it can be, tough. So that's just something to take note of. And then, of course, the final category, which I haven't covered, is siblings. This is the worst category, personally, if you ask me, just because of how long it takes. However, it's still an option. So a US citizen only can file for their siblings. However, the odds of you being in status is very unlikely because it takes about 14 to 17 years, depending on what month of the visa bulletin that you're looking at for a siblings visa, to be available. And most likely, you will not be in status. So it's better if you have a sibling filing for you that you're not in the country. And when that person files for you, it doesn't mean that you can't continue to look for other options that allow you to be in the United States, because them petitioning an I-130 for you doesn't mean that you can't exercise other options if you have it, because you can have more than one of that. The only thing that you can't really have more than one of is your I-485. One of them is going to be canceled. But if someone files for you for an I-130 as your sibling, and then tomorrow you get married, you can then continue with the marriage-based one, but you don't need to withdraw the sibling one. And the reason why I say that is because if you never find any other alternative to get a green card, allow that time to continue, and maybe you'll be eligible based on sibling. The sibling can, even though it takes a long time, it can be a wonderful benefit to families, when the visa becomes available, because, it would cover you, your spouse, the children, so, it can be a blessing to more than one person if it came. It's just that it takes a really long time. I know this topic is a little bit complex and very nuanced, but I just wanted you guys to know. Let me just run it down real quick. Your cousins basically cannot file for you. Grandparents can't file for you. Your nieces can't file for you. No, you cannot file for your nephew. Even if you have the same last name, that is a crime, unless they're your actual child or you've legally adopted them. You can't file for your aunts. You can't file for your uncles. So basically, just think about your immediate family members: spouse, parent, child, sibling. Those are the only people in a family immigration that can petition for you for a green card. Okay? All right. Let me answer some questions. Good morning, Lorna Miles on Facebook. Good morning, Minaj. Good morning, Tanique. Novia from YouTube says, what if you're an immigrant and marry a U.S. citizen and he has a baby in the marriage, turn around, just walk out on you? What can you do? Call me, girl, 407-995-6567. Let us evaluate and see if you qualify as a self-petition, because usually with stuff like that, I suspect there's much more going on. So you can definitely call me, 407-995-6567. You can also send a WhatsApp, 404-333-8751, and we'll evaluate you and see if you can self-petition, okay? Good morning, Novelettes on Facebook. Good morning, Monday. Shari K says, what if your green card holder spouse files for you, but you're out of status? What if your green card holder spouse files for you, but you're out of status? Is there any waiver that can apply to your case so that you can adjust your status in the US? No. There's none. If you're out of status and your green card holder spouse files for you, the only way for you to get your green card is through a hardship waiver that is approved based on the hardship it will cause your spouse, but you must leave the country. You must leave the country, unless, God forbid, something happens with you and your spouse and you guys are, your spouse becomes abusive. If your spouse becomes abusive, then you can adjust your status on your own as a self-petitioner. But otherwise, there's no waiver to allow you to adjust if you're out of status and you're married to a green card holder. Good morning, Davis. Good morning from Georgia. Yeah, it is so hot in Georgia. It is crazy. All right, let's see what else we have here on Instagram. Can a J1 with a 2-year rule file an exceptional hardship waiver if married? So what you need is not a hardship waiver if you have a J visa. What you need is a no objection waiver, and your home country has to not object to it. And the Department of State here too has to say, okay, we accept what they're saying and we'll remove the 2 year requirement. So your process is a little different, but you must remove it in order for you to adjust. So unlike a green card holder who there's absolutely no waiver here in the US. You must do the hardship and consular process if your spouse has overstayed. In a J1 situation, if you're able to get the no objection waiver approved, you can adjust your status in the United States. So that's the difference between the two. Um, Tisha says, what if the person is in the US already? So what category are you talking about? Are you talking about like a spouse with a green card holder or a sibling? What are you talking about? Um, Sonny says, good morning. My brother went to an interview in Nigeria. He's supposed to come for my father's funeral. Is there anything we can do? If you're talking about a B1, B2 visa, there's not really much. I mean, you're at the mercy of the officer that interviewed your brother, and your brother's tied to Nigeria. If they determine that he doesn't have sufficient ties to Nigeria for him to return, unfortunately, you might not have a favorable response. That being said, maybe you can provide all the documentation, everything related to the funeral, and hopefully that will push your case. But it's really hard to get a B1, B2 visas from certain countries. Bomi says, I didn't get Social Security card mailed to me with my EAD. I went to apply for another card and now I have my green card, but my Social Security card is still pending DHS approval. Just go to the Social Security office and go get a new Social Security card if you have your green card. And congrats on your green card. If you're out of status as a student, can your spouse petition I-130 without having any issues? IPAD gone, the answer depends on what is your spouse. Is your spouse a US citizen or are they a green card holder? Because it makes a big difference. Um, So Tisha is asking about her niece. Well, I just answered that question already about your niece, but let me see what you're saying. My niece is living in the US with me. I'm doing an adoption for her. After the adoption, can I do her immigration paperwork? She's 14. So Tisha, if you legally adopt your niece, and she is, and you're a US citizen, once the adoption is legal, yes, you can do the adjustment for her. Lucius says, I'm a J1 student and I applied for a waiver and it was approved. Can I adjust my status? Well, if your waiver was approved, if your no objection waiver was approved both by the US and your home country, and you are married to a US citizen, yes, you can adjust your status. If you're not married to a US citizen and you're not in status, no, you have to do a waiver and go back home. Tokachito says, if you have a child with special needs, can an I-130 petition process quicker? Not necessarily. Generally, I mean, it's for humanitarian basis. If the person is not in the United States, and there's a health issue that's life or death, they may consider that. So it depends on what your child's special needs are. But right now, it's not one of the things that is an option for expedite, unfortunately, on a family-based petition. Tisha says, I'm a green card holder and my husband is a citizen. So you cannot petition for the child. Your husband can probably petition for the child when you've become both legal parents to the child. Both you and your husband have become legal parents. Your husband will be able to petition because you're a green card holder. So the child most likely will not be in status. Even though the child is not in status, another thing I would point out is that if you have a child here that's out of status and they're under 18, when they're being petitioned for, you don't need a hardship waiver. They can go back for their interview and then get approved and come back. But they still have to leave the country. They just don't need a hardship waiver. All right, let's see what the questions I have here. My son's father is in the Navy, but he's a green card holder, not yet a citizen. Can he still file for my son who is in Jamaica? Yes, if your son in Jamaica is not married, he can still file for him. And timeline will depend on if your son is under 21 or if your son is over 21. If he's under 21, visas are currently current for green card holders filing for their children under 21. So this is a really good time to file. Um, Andrea Charles says, "Good morning. What does it mean when you do your Stokes interview and at the end of it, you're told that you will hear from them in 180 days? No, in 120 days. I'm worried because I did the first interview and I was told the same thing. For those of you who don't know what a Stokes interview is essentially basically when they separate spouses for the interview. So they typically will last longer than a normal interview. So they'll first ask you certain questions and then they'll ask your spouse certain questions and they try to go as deep and as intricate as possible just to catch you guys in a lie. Sometimes some officers will bring you back in for what we call a rebuttal period. What that means is that if you guys have different answers that are, different, some officers will bring you back in and give you the opportunity to correct it. Like, if you're saying that your bedroom walls are like purple and your spouse is saying, well they're blue or whatever it is, they can bring you back in and say, well, this is what your wife said, and you're saying it's this other color, and then it's up to you to basically say that you're colorblind and this is what you thought it was or whatever. I'm just using this as an example. And then once that is done, they now have to go over the answer, go over the recording, and then they'll either approve you because you did well on the Stokes interview, or they will basically write a letter detailing, like a notice of intent to deny, detailing all the things that you got wrong. So in your case, Andrea, I don't know how your Stokes interview went, so I can't tell you whether it was good or bad. You know how your interview went. Did you and your husband have very different answers? So all those things will determine what happens, but you should hopefully get one of two things, either an approval or an NOID. Okay. All right, let me see what else we got here. Dejan says, read my question. I can't find your question. These things go up so quickly. So if you can just copy paste it or type it again. Okay. Let's see. Dansania says, how long does it take to get a work permit after biometrics? The answer really depends. You know, like I will tell you time now, and that might not be what your time is. But generally, depending on what you filed for, let me use VAR cases for instance. Like, if you submit a VAR petition and you do your biometrics, usually, I'd like to see within 8 weeks some sort of your work permit coming in. But again, it will depend on when your biometrics is scheduled and have you and where are you in the processing time or the average time. So it's really hard to say, but generally I would say you would see more than 50% of people being in that category. But with everything with immigration, it's never 100% uniform. So I can only tell you where 50% of the pool kind of like settles. So it doesn't mean that's the case for you. You may get yours earlier, you may get yours much later. So it's really hard for anyone to tell you. Kunleo Joe says, do VAWA applicants go for an interview? Yes, they do go for an interview. Sometimes an interview is bypassed, but I know this question has been coming up a lot, so let me explain to you how it works with VAWA. So VAWA cases, before you're scheduled for an interview, you must be approved with VAWA. Your VAWA case must be approved before they schedule you for an interview. The interview is specifically for your I-485. So what that means is that when your VAWA is approved, and let's say you have derivative children under that, you get what we call deferred action. Deferred action means you're not deportable right now. They're not going to deport you, and they're going to allow you to and they're going to give you a new work permit, and you can renew those yearly. You can keep renewing those yearly and renewing your deferred actions yearly. Your I-485 interview happens after you get that. That interview, which is the green card interview, is literally looking through your I-485 form to make sure there's nothing in there that makes you inadmissible. So, I'm sure you see questions there. If you've ever filled out a 485, go look back at your forms. You see where it says inadmissibility grounds, criminal grounds. Have you tried to overthrow the government? Were you in a militia group? Were you a prostitute? Were you an alcoholic? Were you, have you killed anybody? What kinds of crimes have you committed? Have you ever claimed to be a U.S. citizen? So those are the things that they're making sure are okay. To determine that you can be a green card. Sometimes you might have something in your 485 that would require you to get a 601 waiver. And that is a time. So if you already, if let's say you go to your lawyer, or if you're my client, some of my clients will tell you that we already know from the jump that they need a waiver, and we don't waste time. When we submit in the 485, we just submit the waiver. There's no point of wasting time. Sometimes it is literally, it's not very clear, like we can argue it out, that I'm like, let's wait and see what they say. So sometimes it might be there and they will say, you need a waiver for this, because you didn't say this. Let me give you guys an example. An example of that would be, let's say you were coming to the United States, and this is the last thing I got to jump off. Let's say you were coming to the United States and you were not married, but you wrote on your visa that you were married, right? Because somebody told you that if you write that, they will let you they'll give you a visa. But you truly were not married, and you have all the proof and all the evidence to show that you were not married. And, you were able to submit that with your VAWA stuff, show, your certificate of spinsterhood or whatever it is, get all this affidavits, get stuff from the courts to show that you were never married. There is a strong probability that you will need a waiver for that misrepresentation, right? The only good thing for you as a valid applicant when you're doing waivers is that you are your qualifying relative. So in a lot of cases with the waivers, the only people that can qualify you for a waiver is a U.S. or green card holder spouse or parent. But when you're a VAWA applicant, you or even your children can become qualifying relatives for that hardship. So those are the things that they're checking at VAWA 485 interviews after your VAWA has been approved. Generally, most VAWA interviews don't last as long, and the questions do not surround your spouse. It is about you. So like they shouldn't be asking you questions on your abuse. Because VAWA has already established that you've been abused. VAWA has already established that you have a bona fide marriage. So it's just everything else on your form. But generally, they're much more easygoing. Okay, guys, I know I didn't get to some of your questions, but I really do have to jump off. I'll be back on live on Friday at 1:30 this week. I'm not sure actually, because I have the ILA conference. It's like the Immigration Lawyers Conference. So I'm not actually sure. It depends on what my schedule is at the conference. If not, save your question, schedule a consult and get your question answered, 407-995-6567. If I determine what time I'll be on live on Friday, I'll have them posted so you can ask. Otherwise, schedule a consult. All right, guys, I hope you have a wonderful day, and I will talk to you guys later. Bye.